rise.
Yes, Mr. Waddell.
May it please you, my lords, this is an appeal by the claimants in respect of the decision of Stephen Houseman, KC, sitting as the Deputy Judge of the High Court, made on the 13th of November last year, whereby he, amongst other things, struck out of the court's own motion, alternatively dismissed as a matter of discretion, the claimant's application for summary judgment against the first and fourth defendants, Astor 3 and Mr. Sklarov, respectively. The first, fourth, fifth and sixth defendants cross-appeal, arguing that the judge is wrong not to have struck out the entire proceedings. For convenience, I shall refer to these defendants as the defendants. We don't need to worry about the other defendants for the purposes of this appeal. I appear with Mr. Greenberg and Ms. Wilkins. The defendants are represented by Mr. Venkatesan and Mr. Georgiou.
Yes.
Very briefly, the claimants are the victims of a stock transfer lending fraud perpetrated by Mr. Sklarov, who we say is a serial fraudster. His modus operandi involves using false names and misleading trading names, often resembling those of wealthy families associated with widely known legitimate financial firms. And he does this to obtain valuable securities which are ostensibly to serve as a collateral for a loan, but are in fact misappropriated and sold through a web of companies in offshore jurisdictions. In the present case, Mr. Sklarov, operating under the false name Gregory Mitchell, and his accomplice, Mr. Alexei Skatskov, operating under the false names Thomas Astor Mellon and Thomas Mellon, misled the claimants into thinking that they were dealing with legitimate financial institutions owned by the wealthy Astor family. Further details are set out in the judgment, which I'm sure you will have read.
Yes.
On the 5th of March 2025, the claimants applied for summary judgment against Astor 3 and Mr. Sklarov. The application was supported, inter alia, by evidence that had been obtained by BC Strategy UK Limited, BC for short. BC was described by the judge as a business intelligence and strategic consultancy firm. During the course of its investigations, BC approached X, one of the litigation solicitors retained at that time by the defendants,
Yes.
posing as a potential client.
Just to interrupt you, the solicitor was referred to as X in the judgment below. Was any order made to that effect that he should be anonymised?
I don't think so. I'll check. I don't think so.
Well, it seems to us, subject to any argument, that there is probably no good reason why he should be anonymised in that way, but he ought to have an opportunity to make any representations before we name him, if we do.
Right.
So I think what we will do is we will continue in this hearing to refer to him as X, but you must notify him that if he wishes to have his anonymity preserved, he must make written representations to that effect within 7 days.
We'll do so.
Thank you.
And so the approach was by BC posing as a potential client. And during the meetings between the BC operative and X, which were filmed and recorded, X divulged information about the claim. Our position is that the information that had been acquired by BC from X was not privileged because inter alia it was within the scope of the iniquity exception. The BC evidence was exhibited to the evidence in support of the summary judgment application with an explanation as to the claimant's position regarding its non-privileged status. On the 18th of June last year, the defendants applied to strike out or stay the action for abuse of process because of the manner in which the BC evidence had been obtained. They also sought directions as to the admissibility or otherwise of the BC evidence. As you know, the applications came before Mr. Houseman in November last year, and he delivered his judgment on the 13th of November after a 3-day hearing. Before addressing the grounds of appeal in turn, I want to highlight a number of features in the judgment.
Just one question.
Of course.
Very often when a deputy is being allocated to certainly a case of 3 days, the parties are asked whether they have any objections to a deputy hearing the case. Was an inquiry of that?
I don't recall us being asked, but I will check. Now, before dealing with the grounds of appeal in turn, I want to highlight very briefly a number of features in the judgment. First of all, the judge decided to strike out or refuse as a matter of discretion the summary judgment application, even if the claimants had satisfied the elevated merits threshold and there was no other justification for proceeding to trial, i.e. even if the claimants had satisfied both limbs of the test in CPR 24.3. That's paragraph 80. For your note, you'll find that in the core bundle, tab 8, page 134. The judge therefore decided that the appropriate sanction for finding on abusive process was to order a full trial, which on his hypothesis does not or may not need to take place. Secondly, the judge found that the claimants had engaged in unethical behaviour with a view to obtaining an unfair litigation advantage. That's paragraph 25. For your note, core bundle, tab 8, page 122. However, he did not adopt the defendant's emotive label of privilege hunting, and he proceeded on the basis that there was nothing unlawful or illegal about the way the illicit information was obtained from X or transmitted to the claimants or their new solicitors.
How can that possibly be right? It is clearly unlawful to deceive people in order to gain things from them. It may even be a criminal offence under the Fraud Act.
I think he was looking at criminality, and there was expert evidence about that, saying there was no criminality.
Well, why do you need expert evidence?
Well, because of where the meetings took place. They were abroad.
Do you accept it would have been criminal if it had all taken place here?
I need to think about that, but I think you may well be right. So his analysis on abuse of process was founded on unethical but not unlawful conduct. Thirdly, the judge expressly left undetermined the key issues of privilege, confidentiality, iniquity, and trial fairness, stroke impact on the proceedings. He deferred these issues to a separate hearing, the information review hearing, having indicated on an initial analysis that there are arguments either way on privilege and iniquity. That's paragraph 78, subparagraph 3, which you find on page 134 of the core bundle at tab 8.
Has that hearing taken place, or is it awaiting this appeal?
It's been listed for November this year, I think for 3 days. And we say that observation is significant because there's a real prospect of my clients establishing that the material obtained by BC is neither confidential nor privileged. There's one case management point I need to mention before I go deal with my first ground of appeal. The parties...
was it listed in November?
No.
As it were, regardless of this appeal?
No, but the view taken was it was preferable to have this appeal before the information review hearing was listed. I think the information review hearing was listed after this appeal date had been set.
You were so confident that the court would produce a judgment in time for the November hearing.
Absolutely.
Yes.
So there's one short case management point I need to mention. The parties have agreed that certain confidential documents that may be referred to in this appeal should be treated as not having been referred to in open court. It's for this reason that, out of an abundance of caution, we haven't produced a copy of our skeleton to the court usher. Some orders may need to be made in relation to confidentiality at the end of the hearing. We're hopeful that these can be agreed. And so far as I'm concerned, I'm not proposing to refer to any confidential material. But I just mention this because that's what the parties have discussed and have agreed.
Yes, I'm not sure I was aware of that, or indeed which parts of your skeleton you would regard as confidential.
There are a couple of footnotes that refer to the transcripts.
Yes. Well, the court usher ought to have, at any rate, a redacted version.
We'll produce that.
So that can be available in the same way as any other skeleton.
Yeah, I didn't want to do that without mentioning it first.
No, all right, thank you.
And the other thing you need to know, there is a transcript.
Very good.
But no transcriber breaks. It's all been done remotely.
Splendid.
So the legal framework We deal with the legal principles governing the appeals in paragraphs 9 to 10 of our skeleton. That's core bundle, tab 4, page 46. The defendants say nothing about these principles, don't cite any authority in their skeleton, and so we are proceeding on the basis that there is no dispute about the relevant principles, and for that reason I don't propose to say anything more about them at this stage. Our first ground is incompatibility with the overriding objective. The foundation for that ground is paragraph 80 of the judgment. And can we start with that, please? We find that at page 134 of tab 8.
Just to take a step back, is it your position that the Black Cube conduct was not abusive at all, or that it was abusive but nevertheless did not deserve the judge's sanction?
Not abusive at all, but if we're wrong about that, you shouldn't impose a sanction without considering all the circumstances. And therefore any decision on sanction was premature.
Thank you.
So I'm looking at paragraph 80 on page 134, where the learned judge said this: as a matter of inherent jurisdiction and of my own motion, I strike out the summary judgment application. Alternatively, I would decline as a matter of discretion to enter summary judgment or make a conditional order, even if the claimants had satisfied the elevated merit threshold and there was no other justification for proceeding to trial. And it's the final part of that paragraph, starting even if, which we submit reveals a serious error on the judge's part. And the way we read it is this: if the judge is saying he's going to strike out the summary judgment, alternatively decline to enter summary judgment, even if both limbs of the summary judgment test are satisfied. Because his reference to elevated merit threshold, he must be referring to the first part or first limb of 24.3, namely no real prospect of success, and no other justification for proceeding to trial is a reference to the second limb, no other compelling reason why the case or issue should be disposed of at trial.
Well, one other justification or other compelling reason in the language of the rule might have been that all these matters needed to be looked at the trial in order to see what sanction should be imposed in accordance with the alternative submission you just made, that this was premature because you need to consider all the circumstances.
Yes, but he's directed that issue should be heard at a separate hearing, not at trial. And so we would say the proper answer, if you're going to do that, you should have moved the summary judgment application to be heard at the same time as the interim hearing review. And that's the appropriate time to consider all the circumstances and what, if any, is the appropriate sanction. And much will depend on the extent to which the material is in fact privileged and whether or not the iniquity exception applies.
When representatives of a party deceptively and secretly arrange to interview a solicitor to ascertain extensive information about the case he is conducting, it may be that the hope is that what will be obtained will be the confidence and the privilege can be vitiated by iniquity, but they don't know that when they start out, do they?
No.
The process is inherently abusive.
Well, it's unethical. Can I park the question of abusive till I get to the authorities, if I may?
Well, the point is, though, that you may say what the result of this process is that it was, as it were, ex post facto vindicated. But that's something which is some way down the line, and it seems to me that the judge would have been entirely justified in refusing summary judgment on the basis that your conduct is at least arguably unlawful, illegal, and totally abusive, and you are claiming extensive equitable relief.
Well, it's not it's not the way he proceeded.
No, but he could have done that, it seems to me, and that probably, in my view, would have been the right thing to do. So where are we going to go? Where are we going to get to with all this? Because if you are right on your appeal, what you will ask us to do is remit this summary judgment hearing application to be heard at a later date.
Absolutely, at the same time as the information review hearing.
But if the right answer to this is that, well, this all has to be looked at trial to determine the effect of this conduct on the equitable relief you're seeking, then the right answer is to refuse summary judgment on the basis that there's a compelling reason otherwise.
Well, I don't for the moment accept, if I may say so, that this all needs to be determined at trial. I think it perfectly properly and correctly can be determined in advance of the trial. And I'm not saying that the judge was wrong to direct that there should be an...
Well, how can your conduct, your client's conduct, which on the face of it seems to be the most egregious conduct one can imagine in the conduct of in the early stages of litigation, how can that be properly assessed and a proportionate sanction imposed without considering it in contrast with what you allege is the serious fraud perpetrated by the defendant?
Well, we know what happened. We have transcripts and recordings of the meetings, so the judge, I would say, would have all the material available to him to decide what is the appropriate way of dealing with the behaviour.
But no findings have been made as regards the merits of what was disclosed and what you allege against the defendant.
But if the case is susceptible for summary judgment, and we go to the information review hearing and persuade the judge conducting that hearing, that it is a case for summary judgment, the judge will then be able to make that assessment.
Well, maybe, but you're still, at the end of the day, seeking equitable relief, aren't you?
Well, at the trial, most of the relief we're seeking is just common law damages.
Well, as I read it, you're seeking
There's some
declarations, accounts and inquiries.
And damages.
Damages for breach of trust and fiduciary duty, equitable compensation, restitution.
Oh, okay.
All of that is equitable relief, is it not?
It is. But I still maintain that the judge hearing the information review hearing can properly assess the summary judgment application.
Well, how can he assess whether or not what was disclosed was an iniquity unless until at the end of the day one determines whether there was iniquity?
Well, I don't want to get into the content of what was said at those meetings, but we say it's pretty obvious that the iniquity exception applies.
To absolutely everything that was said?
Well, to the key parts of what was said. I haven't, for the purpose of this hearing, I haven't gone through the transcripts. I'm not...
You're saying that in all of those 2 meetings and the dinner, not one thing that was said that was confidential but not revealing of iniquity?
Well, there may be some matters at the periphery that come within that category, but the heart of it, we say, is covered by the iniquity principle, and the judge will absolutely be able to assess what was said without it going to trial. And we say, we had asked to invite the question, why did the judge think it was appropriate to strike out the summary judgment application, even if the summary judgment requirements have been met?
I mean, the judge does present that in rather stark terms, characteristic of moot problems, where to force the students to argue the toughest point, alternatives are excluded by convenient propositions of fact. But of course, very often these questions about do I entertain the summary judgment application have to be decided without the outcome being known. Otherwise, it would be an entirely fruitless exercise to say, do I hear this?
Right.
Where there must be a possibility that if it is heard, there is no triable issue. And yet judges will very frequently say, looking at the conduct of the litigation as a whole in which this issue is presented for summary judgment, not be an appropriate thing for the court to entertain that application at this time. If it had been put that way, would you have the same principal objection that you have to paragraph 80?
Well, that's put in rather softer terms, isn't it? We would still maintain that under the 24(3), if a case is suitable for summary judgment, in other words, if you meet both limbs, it's not an appropriate disciplinary exercise to say that we must go to trial because of the impact on other court users.
Your complaint is actually it's the use of this as a sanction.
Yes, absolutely.
Do you say this should have all gone to the information review hearing?
Absolutely.
Do you envisage that striking out the claim would be a possible outcome of that hearing?
Well, the other side envisage that. We say, no, you're completely wrong.
Okay.
Well, I mean, the judge gave them the opportunity of the second bite of the cherry at the information review hearing. He made it perfectly clear that if it turned out that the material was privileged and not covered by the iniquity principle, then they should be entitled to have another go at striking out. That was his view. We say, when we get there, we say that the striking out on the authorities, on the material he had, was completely wrong. And we will also say, if you were with me and sent the summary judgment application after the information review hearing, we would be saying at that stage, even if the material was privileged, striking out is an inappropriate sanction on the facts of this case.
So if striking out is ruled out as an inappropriate sanction, but if the court does conclude that this is seriously abusive, my lord said the most egregious thing you could imagine, perhaps apart from murdering the other side's chief witness.
Yes.
But assuming that we are in that territory, what, if any, sanctions would be available?
Well, you can exclude
the court's disapproval.
You can exclude the evidence. You can say the current team should not be acting, so as not to get and derive any unfair advantage from the material. You can impose cost sanctions.
You can equitable relief down the line because your conduct in the litigation amounts to unclean hands.
Well, that would, if we make good a very substantial fraud amounting to more than $400 million.
I just mean it's a matter of a theoretical response to poor behaviour in litigation for those who seek equitable relief.
Yes,
it deny them that relief.
Yeah.
Well, that is then why you'd have to have a trial.
I'm sorry.
That's why you would have to have a trial.
That's not. I mean, that's not how he dealt with it, though.
No.
That's so.
No, but what you're inviting us to do, even if we were with you that it shouldn't have been struck out, is to direct that the summary judgment. I mean, we then have to exercise our discretion as to whether to remit the summary judgment to a further hearing. And we have a full range of powers as to what to do with the summary judgment hearing, including we could adjourn it to trial.
Yes, you could. And it's a matter for you whether or not you think we're right in saying it's appropriate to remit it to the information review hearing.
Yeah.
And I risk repeating myself, but all I can say is, if it is a case where there is an obvious deception, an obvious reliance, an obvious loss, why does one need to remit it to trial?
Well, because there are arguments that your conduct in seeking to suborn the defendant's solicitor justifies some form of denial of equitable relief and or other sanction.
Well, I see that. It's not how the case has been run so far. I see the point. But I still...
But that's what we have to decide.
Get that?
Right.
So, in a nutshell, we say that striking out a summary judgment application in circumstances where the requirements for summary judgment are met is inconsistent with the principles of proportionality, expedition and saving costs. And it wastes judicial time on a trial that doesn't need to take place. And it prejudices other court users by taking up time with the trial to prove that Mr. Sklarov is a fraudster in circumstances where his defence to the fraud claim has no real prospect of success. And I've already made the point that there are alternative responses available to the judge, which would have been consistent with the overriding objective. It didn't need to take a highly unusual step of striking out the summary judgment application. So what do the defendants say about these issues? The answer is not very much. To be more specific, they say a grand total of 4 words on ground 1. You'll find that in their skeleton argument at tab 5 of the core bundle, page 88. And it's paragraph 61. Where it says, unnecessary to address grounds 5 and 11, which are parasitic on grounds 2 and 3, and will fall away, or ground 1, which is likely to be academic. And that reveals absolutely nothing about their position. And they fail to engage with the issues that arise under ground 1, which we say are independent of all the problems that arise in relation to the judge's analysis on abuse of process. So, turning to ground 2, the foundation for ground 2 lies in paragraph 44 of the judgment, which you find at tab 8, page 127. And paragraph 44, the judge finds, in the second sentence, there are 2 broad categories of species of abuse of process. One which is concerned solely with the quality of behaviour, and another which is concerned with the impact of that behaviour on the future course of a case and the integrity of its determination. And he cites the Raja and Van Hoogstraten case. And we know that the judge's decision is founded on the category of abuse of process concerned solely with the quality of behaviour, because he expressly deferred consideration of the other category that is concerned with the impact of the behaviour on the conduct of the proceedings. And for your note, you get that from paragraph 70 to 72, starting at page 132 of the same tab, and 83.7, starting at page 136. And my lords, our submission is this, that there is no such category of abuse of process concerned solely with the quality of behaviour, which doesn't involve considering the impact of such conduct on the proceedings.
Why has this conduct not had an impact on the proceedings? It has, for a start, deprived the defendants of their chosen legal team. It has led to a 3-day information review hearing. It has, given the timing of that review hearing, it has delayed the case by a year.
Well, that obviously does amount to impact, but that.
Yes. Quite serious impact, I would have thought.
Yes. what I'm trying to aim at is the judge's decision that there was.
Well, that may be a false target. I know he's set it up for you to aim at, but if there is an impact on the proceedings, we're in the ordinary category, aren't we?
Well, I see that, but I am constrained by what he found and how he found, and we say it's just wrong. It's just an error of law to say that there is a category of abuse solely concerned with the quality of behaviour without any consideration of the impact.
And of course, I do agree with my lord. For myself, I just don't see where any of this is going to get us, because at the end of the day, we're going to have to decide what to do with the summary. If you're right, we'd have to decide what to do with the summary judgment application. And if we can see.
Well, I have to. Sorry, I'm sorry, I didn't mean to interrupt you. No, apologies.
Whatever.
I have to persuade you he was wrong to do what he did. Of course, but if I get over that threshold, then it's a matter for you of whether or not you think it appropriate to remit it to the information review hearing or to send it to trial. But I've got to get over the first hurdle, and the only way I can do that, risk being argumentative, the only way I can do that is aim my fire at what he decided. And
well, if your proposition is that the judge was wrong to strike out a summary judgment application as a response to a finding of abuse, I can see a lot of force in that.
Well, that's
But where's it going to get us?
well. Then you have to decide the appropriate way of dealing with it. So, but I have to get there, and I have to persuade you on the basis of authority that we're right. That the judge was wrong to do that, and of course I have to be mindful of the fact that my learned friend has a cross appeal to the arguing that the whole action should have been struck out at this stage. So I have to take you to the authorities, I think.
Well, do that if you need to. But if your submission is that there is no such category as abuse which is concerned solely with the quality of behaviour, but if you also accept that this conduct did in fact have an impact on the proceedings, then the question ultimately is whether this was abusive conduct, and the answer to that seems at the moment pretty obvious. And the real thrust of the appeal is what the judge should or should not have done about it.
Right. I'm being passed the note. Forgive me
Yes,
for a
we'll
second.
see what that says.
Yes. I think the answer to my Lord's point is that you cannot. Well, if we get to the authorities on considering impact, you have to look at all the circumstances. And even if you were satisfied, as you appear to be, that there is some impact on the proceedings by the approach to X, and I get the point you've made about the fact we've had a delay in hearing and therefore there is some impact, but that's not how you approach the question of sanction. The question of sanction has to be approached by looking at all the circumstances, doing so scrupulously, and deciding what is just and proportionate in all those circumstances. So I still think I have to go through the authorities on my ground 2, even if it transpires that in the end you're much more interested in my ground 6. And the ground 6 may well be where the strength of this appeal lies. But I think I've got to take you through.
All right, well, we won't stop you. Do what you feel you need to know, but you've heard the points in which the court is mainly interested. And
I have.
You will use your time accordingly.
I have. And yes. So what I was going to do, unless it's really very unhelpful, I was going to deal first of all with the proper understanding of the Court of Appeal decision in our nominees.
Yes.
Then I was going to go to Raja, which for obvious reasons, because the judge relied on that for his category. Then I was going to take you to other relevant Court of Appeal decisions. Then I was going to address some further points of principle. And then, fifthly, explain why the judge erred in regarding the two limbs of 3.42b as disjunctive and had a very brief tying of the threads together. And in many ways, the debate between the parties regarding ground 2 boils down to the following question. What's the proper understanding of certain passages in our nominees? One sees that, for example, in paragraph 18 of our skeleton and paragraph 40 of theirs. And the centre of that battleground is paragraph 54 of Lord Justice Chadwick's judgment. But before I take you to that, I need to say something about the concept of abuse, particularly as the focus of our nominees is on the question of when it's appropriate to strike out a claim for an abuse. More particularly, the judgment in that case deals with the two categories of abuse that may justify striking out a case. And we say the starting point for the purpose of understanding what abuse of process means is Lord Diplock's off-cited observation in the Hunter case. And you can get that in the Cable and Liverpool Victoria Authority. Can I ask, is anyone using hard copy bundles?
I am.
Right, so... Sorry, my computer's just... You'll find that at tab 30, people using soft copies, and volume-wise, it's volume 2 of the authorities bundle.
Thank you.
And it's page 751. And at paragraph 42, they refer to the classic summary of abuse of process in Lord Diplock's Dictum and Hunter case. My lords, this is a case about abuse of the process of the High Court. It concerns the inherent power which any court of justice must possess to prevent misuse of its procedure in a way which, although not consistent with the literal application of its procedural rules, it would nevertheless be manifestly unfair to a party to the litigation before it, would otherwise bring the administration of justice into disrepute among right-thinking people. The circumstances in which abuse of process can arise are very varied. It would, in my view, be most unwise if this House were to use the occasion to say anything that might be taken as limited to fixed categories, the kinds of circumstances in which the court has a duty. I disavow the word discretion to exercise this salutary power. And that passage has been cited many times since, most recently by the Supreme Court in Summers and Fairclough. A working definition of abuse of process adopted by both leading counsel in this appeal was set out by Lord Bingham, then Lord Chief Justice and Attorney General Barker. He defined an abuse of process as a use of the court process for a purpose or in a way which is significantly different from the ordinary improper use of the court process. And we say that these observations, together with the Court of Appeal's decisions in Arrow nominees Rakia and Azima, Hamilton and Fayed, and Dodorian and Sims, support our primary submission that where conduct has no impact at all on the litigation's process, it's not abusive, even if it could be characterised as unethical or worse. So in our submission, a failed attempt to obtain privilege is not an abusive process. Similarly, a failed attempt to suborn a witness is not an abuse. Before leaving cable, can I draw your attention to some other paragraphs here? First of all, paragraph 45, which will all be very familiar to you. A claim must be clearly shown to be an abuse before it can be struck out. Striking out of a claim is a draconian remedy, and he refers to Summers, which I'll come back to. Then at paragraph 47, they cite a passage from Alpha Rocks, Solicitors and Allege, in which Lord Justice Voss said this: the cases I've mentioned were right to emphasise in the context of striking out what is effectively factor A, namely the need for litigation to be conducted efficiently and at proportionate costs. The need for compliance with rules and orders is equally important. But it must be remembered that the remedy should be proportionate to the abuse. In the context of this case, it's also worth emphasising, before I turn to the particular circumstances, that litigants should not be deprived of their claims unless the abuse relied on has been clearly established. The court cannot be affronted if the case has not been satisfactorily proved. This aspect is obviously interrelated with whether or not a fair trial remains possible. Moreover, the fact that solicitors have signed bills that appear to be inaccurate or worse is obviously a matter of concern. But that concern doesn't abrogate the need for the issue of whether the bills were indeed inaccurate to be fairly resolved between the parties, if that's possible. So it could be seen that the court is emphasising that when considering whether the proposed remedy is proportionate to the abuse, it's important to consider whether fair trial is possible. And if we go on to page 754, you'll see paragraphs 63 and 64 that Lord Justice Coulson again refers to proportionality and emphasises in 63 that it was a two-stage test. First, the court has to determine whether the conduct was an abuse. Secondly, if it was, the court has to exercise its discretion as to whether or not to strike out the claim. It's at that second stage that the usual balancing exercise and in particular considerations of proportionality become relevant. And in the last sentence of 64, it makes it clear that the finding of abuse does not lead inexorably to the striking out of the claim. And then paragraph 7, page 757, paragraph 89. As with any balancing exercise, the court also has to consider the position of the appellant and in particular the consequences for him if the claim was struck out. So what we get out of this is confirmation that the abuse must be related to the process. It cannot exist in a vacuum, and it must amount to misuse of the court's procedure, or using the judge's formulation, have an impact on the future course of the case and the integrity of its determination. And if it does, then you have to consider all the circumstances. And I turn now to Arrow nominees, as the other side rely on that in support of the proposition that conduct can be abusive irrespective of the impact on the fairness of the trial. We can find that in the first bundle of authorities, tab 7, starting at page 89. That was an unfair conduct petition brought by minority shareholders. In advance of the trial, the majority sought to strike out the petition on the ground that by reason of the production of forged documents by a director of one of the petitioners, a fair trial was impossible. The first instance judge refused that application, but made it clear it could be renewed if further evidence of forgery emerged at the trial. That is precisely what happened. However, the judge refused the second strikeout application on the ground that a fair trial was still possible. The majority shareholders appealed, and the Court of Appeal held that the second strikeout application should have been granted. And the leading judgment was given by Lord Justice Chadwick. And the key paragraphs are paragraphs 53 and 54, starting on page 138. And the defendants say in paragraph 40 of their skeleton, we don't need to turn it up, they say that paragraph 53 is dealing with the fair limb trial of striking out for abuse of process, the first limb. And they say that paragraph 54 is dealing with the second limb. They're wrong about that. 53 has nothing to do with the first limb at all, as will become clear from reading it. In those circumstances, I take the view that it's wrong for the judge to allow the petition to proceed once he'd reached the conclusion that there was a substantial risk that the allegations in relation to the disputed terms of the 1994 agreement were incapable of a fair trial. He recognised correctly that a claim to relief based on allegations of abuse by the blacklist respondents of their powers as directors and shareholders after 1997 would not require any investigation into what had or had not been agreed. But as it seems to me, he failed to appreciate that on a true analysis, the allegations made in the petition were allegations of repressive conduct by Blackledge as supplier or as lender, and were not allegations of repressive conduct by Blackledge as a majority shareholder. Insofar as there were general allegations of breach of duty by Graham and Margaret as directors, those allegations weren't supported by any evidence which the judge identified and are contradicted by the material which was put before this court. In my view, the judge ought to have reached the conclusion that once the allegations in respect to which there was substantial risk that Nigel Tobias's fraudulent conduct had made a fair trial impossible were put on one side and left out of account, there was no case for relief which remained to be tried. So the fact that there was on analysis no remaining case for relief is an entirely different point for striking out for abuse of process. Striking out for abuse of process is dealt with in paragraph 54. It would be open to this court to allow the appeal against the judge's refusal to strike out on that ground alone, but for my part, I would allow that appeal on a second, an additional ground. I adopt as a general principle the observations of Millet J, as it was in Logicrose and Southend United Football Club, that the object of the rules as to discovery is to secure the fair trial of the action in accordance with the due process of the court, and that accordingly a party is not to be deprived of his right to a proper trial as a penalty for disobedience to those rules, even if such disobedience amounts to contempt for or defiance of the court, if that object is ultimately secured by, for example, the late production of a document which has been withheld. But where a litigant's conduct puts the fairness of the trial in jeopardy, where it is such that any judgment in favour of the litigant would have to be regarded as unsafe, or where it amounts to such an abuse of the process of the court as to render further proceedings unsatisfactory and to prevent the court from doing justice, the court is entitled, indeed I'd be whole bound, to refuse to allow that litigant to take further part in the proceedings, and where appropriate to determine the proceedings against him. The reason, as it seems to me, is that it's no part of the court's function to proceed to trial if to do so would give rise to a substantial risk of injustice. The function of the court is to do justice between the parties, not to allow its process to be used as a means of achieving injustice. A litigant who's demonstrated he's determined to pursue proceedings with the object of preventing a fair trial has forfeited his right to take part in the trial. His object is inimical to the process which he purports to invoke. So we say the answer to ground 2 follows from a simple, straightforward reading of paragraph 54. It's clear that both grounds for strikeout involve taking into account the impact, and that's all the impact, of the conduct in question on the proceedings. And that's obvious in the case of the first limb puts the fairness of the trial in jeopardy. But it's also clearly the case in relation to the second limb, such an abuse of the process of the court as to render further proceedings unsatisfactory and to prevent the court from doing justice. Rendering further proceedings unsatisfactory and preventing the court from doing justice is also about actual impact on the proceedings. And I would ask rhetorically, how can one assess whether further proceedings are unsatisfactory without assessing the actual impact on the proceedings? And how can the concept of preventing the court from doing justice be tested without assessing the actual impact on the proceedings? In my submission, this passage provides a short but complete answer to ground two. The judge's analysis cannot be reconciled with this, and we say it follows that the judge was wrong to conclude that there was a category of abuse concerned solely with the quality of behaviour, divorced from the impact of such behaviour on the court's process. And that conclusion is reinforced by Lord Justice Chadwick's reference to Logicrose and Southend. That was the third sentence of paragraph 54. And the best place to see those observations in Mr. Justice Millett, as he then was, is in paragraph 67 of Lord Justice Ward's judgment, which we find on page 141.
Well, before we leave Lord Justice Chadwick, what about paragraph 55?
I'm coming back to that.
Are you coming back to that?
Yeah.
All right. So, sorry, where did you want to go?
I want to go, please, to page 141, paragraph 67, Lord Justice Ward's judgment, where he cites the extract from Logicro's case, where Mr. Justice Millett, as then was, says this: in my view, a litigant is not to be deprived of his right to a proper trial as a penalty for his contempt or defiance of the court, but only if his conduct has amounted to an abuse of the process of the court, which would render any further proceedings unsatisfactory or prevent the court from doing justice. Before the court takes a serious steps, it needs to be satisfied that there's a real risk of this happening, i.e. the risk that it's impossible to conduct a fair trial. So that's the passage on which Lord Justice Chadwick's two limbs are based. In Mr. Justice Millett's formulation, the two limbs are closely intertwined. And this only goes to show that there is an overlap between them. And the point of mentioning that is, as you'll see in due course, the other side said they're meant to be two distinct principles with no overlap at all. And we say that the extract from Logicrose supports the analysis I've been developing, and it undermines the judge's finding that there was a category of abuse concerned solely with the quality of behaviour. And one could test the point this way: the forgeries that were deployed by the director in the proceedings misspoke. The forgeries were deployed by the director with a view to obtaining an unfair advantage. So there could be no doubt that the impact requirement was satisfied here. But say the director had produced some forgeries, but then put them in the bottom drawer of his desk and decided in the event not to use them. We would submit that if he'd done that, there would be no abuse of process, because there would have been zero impact on the proceeding.
I'm just wondering whether, plainly there must be some nexus between the conduct and the litigation.
Yes.
To make it an abusive process rather than bad behaviour. So, for example, underlying conduct said to give rise to a claim in deceit is not an abusive process because that required nexus is not there.
Yes.
Preparation of documents that then never leave the director's drawer wouldn't have the necessary link with the litigation to make that conduct an abusive process, would they?
No.
But does that necessarily mean that only an impact on the actual course of the litigation can do? Or can that nexus be satisfied in some other?
Well, we say it's satisfied by impact on the litigation. And of course, you'll have seen from the other side skeleton that they say a mere attempt to obtain privileged material is an abuse which warrants striking out. That's their position. So, on their case, an unsuccessful attempt to obtain privileged material is an abuse which justifies striking out. So, can we go back to 55, which was on page 138?
But in that example, just to finish, the nexus is met because the misconduct is for the purpose of and in relation to the litigation. If you're right and nexus is not enough, that there also must be impact or consequence. And I suppose we then get into a separate question.
But the forgeries, in one view, does meet the nexus because the forgeries are done with a view to gaining an unfair advantage. Then the person then has second thoughts. But the actual when the forging is carried out, there is a nexus. It's designed to impact on the proceedings. And then he changes his mind. So having identified the relevant principles in 54, Lord Justice Chadwick then applies them in paragraphs 55 and 56. I don't know whether you would regard it as appropriate if I asked you to read some of these paragraphs in the interest of saving time.
Yes, certainly.
Thank you. Thank you.
Isn't what is described there similar to what has happened or will happen in this case, so that there will now need to be either the information review hearing or an investigation at trial to see exactly what it is that's come out, to what extent any material is covered by iniquity and to what extent it's not,
Well,
and what impact that should have on the relief which the court might otherwise be willing to grant.
well, what he's saying
That's
is
where we are.
what he's saying is that a fair trial was impossible, and therefore the appropriate sanction was striking out. If you go back to 53, the only ground on which the first instance judge thought it was possible to have a fair trial was no longer an issue in the case. So the paragraphs 55 and 56 and 54 proceed on the basis that because of the campaign of forgery which continued during the trial, a fair trial was impossible. So there's nothing in those paragraphs to support the view that there's a category of abuse concerned solely with the quality of the behaviour. We also need to look at Lord Justice Ward's judgment, which emphasises the need to have regard to the overriding objective. The key paragraphs there are paragraphs 72 to 74, which one finds on page 143. And again, if I may, I'd ask you to read paragraphs 72 to 74. And these paragraphs, we say these paragraphs make it clear that although the fairness of the trial is a factor of very considerable weight, which may often be determinative, it's not the only factor. Other matters, namely those identified in the overriding objective, must be put in the scales and weighed. And for completeness, I note that in paragraph 77 of the judgment, Lord Justice Ward says he's read the draft judgment of Lord Justice Chadwick and he agrees with it. Before moving on, my lords, I should make it clear that we consider the defendants have misunderstood what Lord Justice Chadwick is saying in paragraph 54. I will leave the detailed critique of their reasoning to my reply, if necessary. I'll just make a few brief points at this stage. First of all, they wrongly assume that the two limbs of the test are two distinct principles with no overlap. Secondly, they fail to appreciate that rendering further proceedings unsatisfactory necessarily involves consideration of the impact of the abuse on the proceedings. Thirdly, and importantly, they omit from their quotation, which they set out in the body of their skeleton, the key sentence in Lord Justice Chadwick's judgment, starting at 54G. 54G says the reason, as it seems to me, is it's no part of the court's function to proceed to trial if to do so would give rise to a risk of substantial injustice. Now, the reference to substantial risk of injustice necessarily requires the court to consider the impact of the conduct on the proceeding. They also, the next objection is they read far too much into the word object in the penultimate sentence. Lord Justice Chadwick was clearly looking at consequences and not saying that intention alone would suffice, even if the intended aim was not achieved. And then finally, there's a mismatch between what they say in paragraph 41 and their conclusion at paragraph 43, which purports to endorse the judge's approach. So having explained why the judge's proposition in paragraph 44 cannot be reconciled with our nominees, I'd now like to take you to Raja and Van Hoogstraten, because the judge relied on paragraphs 31 to 32 of that case for the proposition that there is a category of abuse concerned solely with the quality of the behaviour. And we say that's a misreading of that case. We find it in tab 16 of the authority bundle, that's volume 1, starts at page 363. And as I'm sure you know, in this case, the claimant, the late Mr. Raja, sought an order striking out the defence and counterclaim of Mr. Van Hoogstraten, and an order that he be debarred from defending the action and prosecuting his counterclaim. The reason that he was seeking that relief is that Van Hoogstraten had been complicit in Mr. Raja's murder. And we see that in paragraph 2 in the penultimate sentence, where the judge says, I held that Mr. Van Hoogstraten was responsible for the murder. In light of that finding, Mr. Raja's estate applied for the defence and counterclaim to be struck out. And from paragraph 6, the judge, Mr. Justice Lightman, describes the issues in that case. I need only say by way of very high-level summary that the dispute between them involved highly fact-sensitive matters such as the existence of oral agreements and extensive allegations of fraud against Mr. Van Hoogstraten. Now, can we look very briefly at the evidence adduced by Mr. Raja's estate in support of the strikeout application? We find that on page 368. Paragraph 22, where it says this: the thrust of the evidence of the murder of Mr. Raja has prevented the trial proceeding on an equal footing and jeopardised a fair trial because while Mr. Raja, the vital witness for the claimant, can no longer be called to detail and explain his complex and unusual business transactions with Mr. Van Hoogstraten. Leaving aside Mr. Van Hoogstraten, only Mr. Raja was able to speak to his dealings. To a very large part, the agreements, negotiations, discussions, and events directly involved Mr. Raja could only realistically be the subject of oral evidence. 3, Mr. Raja made no significant witness statement before his murder. 4, the problem for the claimant is aggravated by the fact that Mr. Van Hoogstraten's amended defence and counterclaim, which was the first information and first informative pleading on his behalf, raising issues of authenticity of documents, as well as putting in issue all of the relevant facts, though meant to be served in June 1999, was not served until after the murder, when instructions on its contents could no longer be obtained. The murder has enormously increased the difficulty, cost and complexity of preparing for the case, and so on and so forth. And Mr. Van Hoogstraten didn't serve any evidence at all, as you see that from paragraph 23. And Mr. Justice Lightman pithily summarises the impact of the murder on the proceedings in paragraph 27, which you find on page 371. There is force in Mr. Van Hoogstraten's submission that the pleadings during Mr. Raja's lifetime that on the pleadings during his lifetime there were substantial factual hurdles facing his case. They were not insuperable. There was no reason to believe that Mr. Raja could not have explained all that and all that happened in a satisfactory manner and established his case as pleaded. Mr. Van Hoogstraten, however, by murdering him, set out to deprive him of the opportunity to do so and succeeded in doing so. The hurdles facing the claimant today are practically insuperable. So that's the background. And paragraph 28, he notes, striking out as a sanction of last resort, which must be exercised in line with fundamental human rights of access to the courts. And then we then come to the paragraph on which the judge relied, and that's paragraphs 31 and 32. Paragraph 31, he refers to arrow nominees, the two separate grounds arrow nominees. Says the first ground is where the conduct of the party has jeopardised a fair trial. In my judgment on the facts of this case, there can be no doubt that Mr. Van Hoogstraten, by his murder, has done exactly that and more. The removal of the vital witness for the claimant renders a fair trial no longer possible and renders any further proceedings unsatisfactory. Mr. Van Hoogstraten clearly recruited the thugs to murder Mr. Raja, so he couldn't face with equanimity the prospect or outcome of a fair trial with the attendance of Mr. Raja at the trial. Striking out the defence and counterclaim is plainly proportionate and just. There are available no counterbalancing measures which can secure a fair trial or fair result of the trial, and no other less draconian alternative order can achieve justice. Mr. Van Hoogstraten has by his own actions denied himself the right to proceed with his defence and counterclaim. The second ground is that the conduct is such a flagrant abuse of process and such a challenge to the administration of justice that irrespective whether a fair trial is possible, an order to this effect is required in the interest of the administration of justice. No greater challenge to the administration of justice and no greater perversion of the course of justice can be conceived than the murder of the opposing party to obtain advantage in the litigation. This conduct which no court with its necessary concern for the administration of justice can tolerate. Such an order is both proportionate and necessary. And we say, because of the express reference to arrow nominees, this judgment should not be seen as departing from it. And therefore we say that if our understanding of arrow nominees is correct, then Van Hoogstraten doesn't depart from it. And it seems that the defendants agree with that analysis because they proceed on the basis that our analysis of arrow nominees is wrong and that therefore we've misunderstood Van Hoogstraten. So with regard to paragraph 32, the defendants read far too much into the use of the words in brackets, in parentheses, irrespective whether a fair trial is possible. This acknowledges that there is a fair trial limb, but it doesn't mean that the other limb has nothing to do with the impact on the proceedings. And when Mr. Justice Lightman refers to the no greater perversion of the course of justice, there's no reason to think that it's excluding from consideration the impact of such conduct on the proceedings. Indeed, his language suggests precisely the opposite. Perversion of the course of justice is about actual impact on the proceedings. And the next paragraph, paragraph 33, supports the submissions I've been making. As you can see, the breadth of the considerations that go into the mix in reaching the conclusion that the matter, the claim, defence and counterclaim should be struck out.
So are you saying that what paragraph 32 means is that there still has to be an impact on the proceedings,
Exactly.
although it may not be an impact which renders a fair trial impossible?
Exactly.
If
But the question of, I'm sorry.
If Mr. Raja died of natural causes, no one would have been able to mount an argument that the fair trial of the claim was impossible.
No.
Equally, there can be no doubt in a clash between two witnesses of oral exchanges, etc., that if one has a live witness and the other does not, the latter is at a significant forensic disadvantage.
Yes.
So you can have cases in which we recognise a fair trial is possible, yet the balance between the parties has been altered to the detriment of one of them.
Yes. But a key consideration, but not the only consideration in the second limb of our anomalies, is whether a fair trial has been rendered impossible as a result of the conduct. And if you read paragraph 33, the learned judge refers to the facts of this case. And he refers to the overriding objective. And all these are pointers to having a look at the impact of the conduct in question on the proceedings, including an ability to have a fair trial. And
well, can you really say that? He says very clearly that it's such a flagrant abuse and such a challenge to the administration of justice that, irrespective of whether a fair trial is possible, it's required in the interests of the administration of justice.
well, that's only a nod to the first limb. He's looking at the second limb now. He's already said under the first limb a fair trial is impossible because of the murder. The difficulties faced by Mr. Raj, or rather his estate, are now insuperable. Therefore, I'm striking out under the first ground. He then goes on to consider the second ground, which requires one to consider the overall justice and whether or not it's possible to have a fair trial, and other considerations, as we got from Lord Justice Ward's judgment. And that other considerations can include, if the conduct has meant that the trial is so skewed, you're now spending weeks and weeks dealing with the misconduct rather than dealing with the actual substance of the claim.
So the outcome of this case, if the difficulties were indeed insuperable, is that the claimants were entitled to relief, which they were unable to prove.
Yeah. It appears so.
Okay.
But the second limb, to just go back to the question I was asked, the second limb in our anomalies is that it's got to be such an abuse as to render further proceedings unsatisfactory and to prevent the court from doing justice. And that question can only be answered by looking at all the circumstances. So we say Van Hoogstraten does not support the judge's proposition in paragraph 44. But our alternative case is if my lord are not with me on this, and Van Hoogstraten is to be read as departing from our anomalies, and we respectfully suggest it's wrongly decided. Because our anomalies makes it absolutely clear that whichever limb you're looking at, you have to look at the overall impact on the proceedings. You have to ask yourself the question whether a fair trial is possible, and you have to ask yourself the question whether or not further proceedings have been rendered unsatisfactory, and can the court do justice? And if you're with me on the proper understanding of our anomalies and Van Hoogstraten, that's sufficient to dispose of ground two. But there are a few additional Court of Appeal authorities that help draw a line under the matter. And they are Dorian, Hamilton and Al-Fayed are narrow nominees. Sorry, Hamilton, Fayed and Rakia. And when we get to Rakia, it's a hacking case and the Court of Appeal held no abuse, even though there was illegal conduct. But starting with Dorian and Sims, we find that in Volume 1, tab 19, and it starts at page 415. And this appeal was concerned with a number of issues, including whether the judge erred in making findings about certain fraudulent misrepresentations. All the challenges to the judge's findings were dismissed. There was also an attempt by the respondents to have the appeal struck out under 52.9 on the basis that the documents discovered after trial showed that the appellants had misled the trial judge. That application was also dismissed, but it was in that context that arrow nominees was discussed. In paragraphs 221, starting at 457, just for your note, from 221 through to 226, there's a useful summary of arrow nominees, but I don't need to take you through that. It's ground I've already covered. We're interested in paragraph 233 on page 459, where the previous paragraph relates to the first ground in arrow nominees, namely the ground with concern with a fair trial. And they conclude in respect to the first ground that that ground is not made out. And then they deal with a second ground in paragraph 233. That leaves the alternative ground established in arrow, namely that the parties had by their conduct forfeited their rights to bring any appeal. In our judgment, this turns on the true interpretation of paragraph 54 of the judgment of Lord Justice Chadwick in Arrow, with which the other members of the court agreed. We consider this paragraph is not to be read as meaning that the litigant who's demonstrated he's determined to pursue proceedings with the object of preventing a fair trial is taken to have forfeited his right to take part in the trial in every case. Lord Justice Chadwick is careful to emphasise that the litigant's conduct had put the fairness of the trial in jeopardy, and the court's power to strike out the proceedings was not a penalty for disobedience with the rules. This interpretation of paragraph 54 is consistent also with Article 6 of the European Convention on Human Rights. Any restrictions on access to the court must, amongst other things, be proportionate. We don't consider the judgment of Lord Justice Ward, who agreed with Lord Justice Chadwick, and there was the only other member of the court to give reasons, is inconsistent with this interpretation, since he relies on the overriding objective in the CPR, which requires a case to be dealt with in a proportionate manner. In the Arrow case, as Lord Justice Ward points out, the forgeries carried out by the petitioner had greatly increased the length of the trial. And what they make it clear is whether the litigant has forfeited his right will depend on all the circumstances, including the consequences of conduct. And a key factor for consideration is whether the conduct will put the fairness of the trial in jeopardy. And that cannot be reconciled with the proposition or with the submission the other side make that Arrow nominees is authoritative for the proposition that misconduct by a litigant can of itself be abusive so as to justify a striking out, irrespective of its impact on the fairness of the trial or the litigation. And the Court of Appeal made it absolutely clear in Dorian and Sims that in discussing the context in discussing the second limb in Arrow nominees, the impact on proceedings is a relevant consideration. And that's the only way to make sense of the reference to putting the fairness of the trial in jeopardy when considering the second limb. And it also explains why the interpretation of paragraph 54 of Arrow nominees is consistent with Article 6 of the ECHR. And similarly, the need for proportionality is yet a further reason why the impact of the conduct needs to be taken into account together with all the circumstances. And we say that paragraph 233 of Dorian and Sims is fatal to to the judge, to the defendants and the judge's position on ground 2 that there is a category of abuse that's concerned solely with the quality of the conduct, without the need to consider its impact in all the circumstances.
In a sense, that would be to punish.
Exactly.
Or just as Chadwick says, it's not punishment.
And it's not meant to be punitive. And that's clear. And the next case is Hamilton fired, which I'm sure you recall. That case arose out of the notorious cash for questions scandal. Neil Hamilton brought libel proceedings against Mohammed Al-Fayed after the latter claimed during a television interview that Mr. Hamilton had accepted cash payments in return for tabling parliamentary questions on Mr. Al-Fayed's behalf. There was also a separate allegation of corruption involving Mr. Hamilton soliciting a fee from the oil company Mobil in return for moving an amendment to a finance bill. Now, the jury found that Mr. Hamilton was corrupt, and for the purpose of seeking permission to appeal, Mr. Hamilton sought to adduce fresh evidence that shortly before trial, Mr. Al-Fayed had purchased privileged documents stolen from the dustbin outside Mr. Hamilton's counsel's chambers. The Court of Appeal admitted that fresh evidence and concluded that when paying for the documents, Mr. Al-Fayed's right-hand man was acting on behalf of Mr. Al-Fayed, but the Court of Appeal ultimately dismissed the application for permission to appeal. And if one reads paragraph 7 to 12 of the head note, which I invite you to do in due course, I'll give you the reference in a second, one can see that the analysis is focused on the impact of the conduct in question on the proceedings or lack thereof. And as we'll see when we're looking at the body of the judgment, the Court of Appeal, that the Arrow nominees issue did not arise in light of their findings about the lack of impact of the conduct in question on the proceedings. And that's significant for a number of reasons. First, in relation to our appeal, it sheds light on the Arrow nominees test. It makes plain that both limbs of Arrow nominees are concerned with real impact on the proceedings. Second, in relation to the defendant's appeal, it illustrates that striking out is not the only appropriate sanction when a party attempts to obtain or obtains privileged documents. Here, the defendant was complicit in the purchase of wrongly obtained privileged documents, but the claim was not struck out. I'll come back to that second aspect when I get on to the defendant's appeal in due course. Now, we can find the judgment. It starts at page 146. It's tab 8, so it's volume 1 again. And I think we could pick it up at paragraph 35 on page 159. And you'll see for paragraph 35 onwards, they deal with Arrow nominees. The submission was that not merely should the jury's verdict be set aside, but that his misconduct should disqualify Mr. Al-Fayed from further participation in the trial, so that judgment should be entered for Mr. Hamilton for damages to be assessed. He submitted the recent decision of this court in Arrow nominees demonstrates that this can be the appropriate response of the court to abusive process or serious misconduct, even where this has not rendered a fair trial impossible. They then summarise in paragraph 36, they then summarise the facts in Arrow nominees. In paragraph 37, they then cite paragraph 54 from Lord Justice Chadwick's judgment. In paragraph 38, they refer to Lord Justice Ward's judgment, and in particular, the added complexity and subsequent substantial increase caused by the misconduct. And that clearly relates to the Lord Justice Chadwick's second limb, as we state in our skeleton, because it goes wider than just fair trial considerations. If we drop down to paragraph 40, we can see the questions the court asked itself, or the court formulated. First of all, was Mr. Al-Fayed party to the purchase of documents protected by legal professional privilege? Secondly, is there a real danger that those documents gave Mr. Fayed a procedural advantage to which his success in the action was attributable? Thirdly, had the jury been aware of Mr. Alfayed's conduct, might this have had such an effect on his credibility and that of his witnesses that the jury would have found against him rather than his favour? Fourthly, has Mr. Alfayed's approach to this litigation had so serious an effect on the trial process that he should be disqualified from advancing a positive case? And we can skip ahead to what the Court of Appeal held in relation to the fresh evidence that permitted to be introduced. That fresh evidence is itemised at paragraph 68, or is introduced at paragraph 68, and you can see that from paragraph 69 the nature of the documents in question. That's on page 169. And clearly highly privileged material. Desmond's shopping list, a detailed list of inquiries which Mr. Desmond Brown, leading counsel, wished to be carried out. Schedule of unidentified credits, a bank account, a skeleton argument on a side issue, a fax letter enclosing the draft witness statement of Mr. Edwards, who'd been a security guard at the Park Lane premises at the relevant time, a letter from his solicitors relating mainly to financial information, fax from Adrian Page to Mr. Hamilton's solicitors, and so on, and containing a draft response to the objections to witness statements, etc. So clearly highly privileged material. And to find the answers to the questions formulated in paragraph 40, can we go first of all to paragraph 108 on page 180, where you see they answer the first question in the affirmative. So Mr. Alfayed was responsible for purchasing privileged documents. And then from paragraph 109, they turn to the second question, namely, is there a real danger that these documents gave Mr. Fayed a procedural advantage? And the conclusion about that can be found at paragraph 122 on page 183. In summary, the evidence doesn't suggest that the documents purchased by Mr. McNamara with the authority of Mr. Alfayed were used by him to obtain a tactical advantage in the litigation, let alone they might have enabled him to obtain a favourable verdict when otherwise he might not have done so. Mr. Hamilton has not made out a case for setting aside the verdict on this ground. And then they ask the third question, whether the fresh evidence would have had any impact on Mr. Alfayed's credit, and that is answered in paragraphs 124 to 125. And in summary, the Court of Appeal concluded it would not have had any such impact because Mr. Alfayed had no credit to begin with. And then we then get to the disposal of the fourth issue in paragraph 127, where they say the fourth question doesn't arise. And the court's approach strongly supports the view that both limbs of the abuse of process in the Arrow nominees sense involve consideration of the impact of the proceedings. And it's impossible to reconcile with the defendant's argument that striking out is the only appropriate remedy when a litigant obtains or seeks to obtain privileged documents.
Well, obviously the court decided what it decided, but I would have thought that in most cases, if you have a detailed insight into your opponent's thinking and their strategy in the case, and the kind of lines of inquiry they want to pursue, then it's going to be almost impossible to investigate to what extent that gives you an advantage and to what extent it doesn't. I find it very hard to see how that could sensibly be determined.
Well, I would say it's very fact sensitive. It depends on all the circumstances. It depends what material you've had. It depends whether the material you've obtained is central to the claim or collateral and so on and so forth. But it's quite clear from Alfayed, the Court of Appeal's decision, that they were looking at the impact of what had been obtained unlawfully. They say the documents were stolen from the dustbins, looked at the impact on the proceedings, and did not go down the route of saying, well, just because you paid for privileged documents, we're therefore going to strike out the claim. So the next case is Rakia and Azima. That can be found in tab 33, which is volume 2, starting at page 798. And it's an important authority because it's not only relevant to several of our grounds of appeal, but it also provides a complete answer for the defendant's cross-appeal. And the background to this appeal was a dispute between Rakia, which is the state investment entity of the Emirate of Ras Al Khaimah, and the defendant, a businessman called Mr. Azima. And by way of brief overview, the judge at trial held that Mr. Azima had defrauded Rakia, included by way of fraudulent misrepresentations, bribery, and unlawful means conspiracy. A part of Mr. Azima's defence was that the claim should be dismissed or struck out, and that Ms. Rakia had relied upon confidential emails which had obtained by its unlawful hacking of his email account. As I'll show you in due course, the Court of Appeal acknowledged that these confidential emails might contain privileged material. The judge at first instance held that Mr. Azima had not made out his hacking allegation. On appeal, Mr. Azima's case, the judge should have found that Rakia was responsible for the hacking and struck out the claim. As we'll see, the Court of Appeal was prepared to assume the hacking point in favour of Mr. Azima, and the strikeout analysis therefore proceeded on the basis that Rakia was responsible for obtaining Mr. Azima's confidential and potentially privileged documents, the result of hacking, and that the claim would have failed but for the existence of documents obtained as a result. And we get that from paragraph 40 on page 815. Before considering the grounds attacking the judge's rejection of Mr. Azima's hacking claim, it's convenient to consider what the consequences would be if that allegation were to be established. We will assume for present purposes, A, that Rakia's case would have failed but for the existence of documents obtained as a result of the unlawful hacking of Mr. Azima's computer, B, that Rakia was responsible for that unlawful hacking, and C, that at least some of Rakia's witnesses gave dishonest evidence about how Rakia came into possession of the hacked material. In paragraph, rephrase that, for present purposes, we don't need to spend much time on the admissibility exclusion analysis, but I would mention briefly a few points. First of all, in paragraph 41, the Court of Appeal refers to the general rule that torture aside, relevant evidence is admissible, and the court is not concerned with how it's obtained. And the Court of Appeal went on to acknowledge that the presumptively hacked materials were not only confidential but potentially privileged. And we get that from paragraph 47 on page 817. There are in addition two other points to be made. First, the materials which were obtained through hacking. Mr. Azima's emails were documents as defined by CPR 31.4. Ex hypothesized they were within his control. Accordingly, as Mr. Lord accepted, an order for standard disclosure would have required him to disclose those documents, other than the documents properly covered by legal professional privilege, insofar as they either supported Rakia's case or adversely affected his own case. It follows that those materials ought to have been available to Rakia by the time of the trial. This is a point that Mr. Justice Ricks made in Dubai Aluminium. Second, the materials revealed serious fraud on the part of Mr. Azima, which would have been a very serious bar to the grant of equitable relief in his favour, as noted in Astor.
The position is different here, isn't it, in that you obtained information from X, some of which was then sought to be deployed, but there was no question of getting any documents from him,
no,
as I understand it, which would then ought to have been disclosed
no,
when disclosure came around.
But we're still in the same territory of privilege. So the both confidential and privileged material was obtained in the Azim case. Obviously, privileged material did not have to be disclosed, but the remaining documents did.
It's not saying here, is it, that privileged documents were disclosed or were obtained on the hacking, simply that if they had been, then those wouldn't have been disclosable in due course?
Yes, but if one stands back from it and one goes into someone else's computer and downloads all their documents relating to a particular piece of litigation, the inference is you're going to get privileged material as well as confidential material.
Yes. Although I think, unless you have other passages in mind which I've forgotten about, privilege was not really the focus of the argument.
No, it wasn't. The focus was on the confidential material that had been obtained, but they did acknowledge that included within the hacking may well have been privileged documents. And I would say it's pretty obvious that there would have been. By the very nature of hacking, you go into someone's files and download. You don't know what the contents are until you look at them. And obviously, the subject we're interested in here is strikeout. And the question arose post-trial. The relevant section starts at paragraph 51 on page 818. And I would invite you to read yourselves in due course paragraphs 51 to 65. But for the moment, I'll just highlight a few key points. Paragraph 52 refers to the Supreme Court decision in Summons and Fairclough, and the case in which the trial judge held that the claim was substantially fraudulent but nevertheless refused to strike it out. I want to read now, for convenience, some from the Summers and Fairclough decision. First of all, in paragraph 52, they cite paragraph 41 of Summers and Fairclough. The language of the CPR supports the existence of a jurisdiction to strike out a claim for abuse of process, even where to do so would defeat a substantive claim. The express words of CPR 3.42b gives the court power to strike out a statement of case on the ground that it's an abuse of the court's process. It's common ground that deliberately to make a false claim and to adduce false evidence is an abuse. It follows from the language of the rule that in such a case the court has power to strike out the statement of case. There is nothing in the rule itself to qualify the power. It doesn't limit the time when an application for such an order must be made, nor does it restrict the circumstances in which it can be made. The only restriction is that contained in CPR 1.1.2. The court must decide cases in accordance with the overriding objective, which is to determine cases justly. Having held that the court had jurisdiction to strike out a claim, the court went on to hold at 43, while the court has power to strike out a claim at the end of a trial, it would only do so if it was satisfied that the party's abuse of process was such it thereby forfeited the right to have his claim determined. The Court of Appeal said this is a largely theoretical possibility, because it must be a very rare case in which at the end of a trial it would be appropriate for a judge to strike out a case rather than dismiss it in a judgment on the merits in the usual way. We agree and would add that the same is true, whereas in this case the court is able to assess both the liability of the defendant and the amount of that liability. Then at 49, the draconian step of striking out a claim is always a last resort, a fortiori, where to do so would deprive the claimant of a substantive right to which the court had held he was entitled after a fair trial. It's very difficult indeed to think of circumstances in which such a conclusion would be proportionate. Such circumstances might, however, include a case where there has been a massive attempt to deceive the court, but the award of damages would be very small. And at 61, the test in every case must be what is just and proportionate. It seems to us it will only be in the very exceptional case that it will be just and proportionate for the court to strike out a case after trial. And what's just and proportionate cannot be considered in isolation without looking at the impact of the conduct in question on the proceedings. Now, whilst this was a case of striking out after trial, those fundamental principles have been applied in other cases, including cases where the application to strike out is made early in the proceedings. One such case is the Misapplication and BHP case that I'll come to later. And I rely on paragraph 56, where the court, as you'll see, states that no case has been brought to its attention where a genuine claim was struck out solely because of the manner in which the evidence was obtained, let alone a case where that evidence showed fraud. That's the last sentence there. No one has brought to our attention in which a claim, no case has been brought to our attention in which a claim was struck out solely because of the manner in which evidence was obtained. even though the underlying claim was both genuine and well-founded, let alone a case in which the unlawfully obtained evidence has demonstrated fraud on the part of the defendant. And that paragraphs 57 through to 61, the court emphasised the difference between fraudulent claims and claims supported by collateral lies, and it concludes at paragraph 60 that the unlawful conduct was not central to its claims. Put another way, any unlawful conduct by Raki in obtaining the emails was not central to its underlying claim against Mr. Azima. Same applies here, of course. And they go on to say at 61, in the present case, insofar as Mr. Page and Mr. Halabi told lies, they were collateral, lacked centrality in this sense. They didn't go to the merits of Raki's underlying claims. And paragraph 62 is important. Three other points are worthy of note. First, as we said, the hacked materials ought to have been disclosed by Mr. Azima anyway, except to the extent that they were legitimately covered by legal professional privilege. Second, to strike out Raki's claim would leave Mr. Azima with the benefit of his fraud. That element of public policy in civil cases is at least as strong, if not stronger, than disapproval of the means by which relevant evidence is gathered. Third, there are other ways in which the court may express its disapproval of the conduct of a party found to have procured relevant evidence by unlawful means, notably by penalties and costs, or perhaps the refusal of interest on damages awarded. And paragraph 63, in our judgment, even if the judge...
I mean, cost penalties are pretty trivial compared to what's at stake here, isn't it? Aren't they?
I mean, in terms of what's at stake in the overall action, absolutely. Claims minimum of 300 million. But it's
we don't know, do we, what your clients paid Black Cube?
No, you don't.
Why don't we know that?
It wasn't before the court.
Well, why was the letter of engagement redacted?
Well, the view was taken that it wasn't relevant to the proceedings.
Well, how is it not relevant to know how much money, what incentives Black Cube had to cut corners or act illegally?
Well, it may be on reflection that the decision to redact for commercial sensitivity wasn't well judged, but that's why it happened.
Yes, well, we want to see an unredacted version.
Okay. That will be arranged.
All right, thank you.
Paragraphs 64 and 65 are important. They say this. In paragraph 42.3 of the re-amended reply, Rakia pleaded, even if Rakia had been responsible for obtaining documents unlawfully from Mr. Azima, the public interest in the court reaching the correct decision on the basis of all the evidence available would substantially outweigh any such unlawfulness. Accordingly, Raki's claim based on those documents would not constitute an abuse of process, nor would there be any basis for excluding any of those documents from the proceedings. In our judgment, that was a valid plea. So those paragraphs make it clear that the question of abuse of process cannot be considered in a vacuum, divorced from questions of overall justice and impact on the proceedings. It follows from those authorities, my lords, that there cannot be a category of abuse of process concerned solely with the quality of behaviour that ignores any impact or any consideration of the impact of that conduct on the proceedings. And note also, please, what we say at paragraph 19 of our skeleton, that's tab 4, pages 49 to 50. And I now turn to the submissions made in paragraphs 47 and 48 of the defendant's skeleton. We find that in the core bundle at page 84. 47 is the proposition that the outcome in Van Hoogstraten would have been the same if it had been a Part 8 claim. So, unlike the second sentence, unlikely the result would have been different had the late Mr. Raj brought a Part 8 claim, turning purely on a point of law. And we ask the question, why? If the case turned on a pure point of law, the murderer could not have had the object or intention of impacting the proceedings or gaining an unfair advantage. And the murder would have had no actual impact on the proceedings. It therefore would have been entirely different from the actual facts of Van Hoogstraten, in which the obvious compelling point was that the murder prevented the key witness from giving evidence in trial and made a fair trial impossible. And then for subparagraph 2, they say this. C's case would mean that it could never be an abusive process to intimidate, blackmail or hack an opposing party or their solicitors or the judge unless a litigation advantage is actually obtained as a result. But whether it's abusive to threaten an opposing solicitor with violence or hack into their email account in an attempt to obtain privileged information should not turn on the solicitor's bravery or the robustness of their IT systems, as it would on C's case, what is abusive is the attempt, irrespective of whether it succeeds. Now, we say there's no authority for the proposition that an attempt to hack or threaten the other side's solicitor is an abuse. The point that they seek to make assumes the correctness of their position and mischaracterises our case. Our case does not depend on the bravery of the solicitor or the robustness of the IT system.
If I know that my solicitors are being hacked or threatened, isn't that, and even if they have so far had robust IT systems and not yielded to any threats, isn't that going to damage the extent to which I feel able to confide my case to them? They've stood up to the threats so far, but the threats may get nastier, and who knows what may be disclosed.
Well, if there's an attempt to hack and that attempt fails, our case is that that is not an abuse because there's no impact on the proceedings. If there's an attempt to threaten and the threat fails, there's no impact on the proceedings.
So I just have to put up with it until such time as
there's the steps that can be taken
into the threats.
No, because the steps can be taken to stop the steps continuing. There's injunctive relief that can be obtained. They're not without a remedy. It's just whether the very short point we're making here is that the question of abusive process cannot be assessed in a vacuum. It has to be assessed in all the circumstances. And the key question is, what is the impact on the proceedings? They then in paragraph 48 say that if we were right, that would give rise to an unprincipled distinction between the treatment of abuse in civil and criminal law. This is because the existence of affronted justice abuse, independently of its impact on the fairness of any trial, is well established in the criminal law. The first point to make is that even if it's right that the criminal law does take a different approach to arrow nominees, that is not anomalous. That's merely a recognition that different considerations apply in the criminal context. And all of the cases in which they rely on their paragraph 48 arise out of serious misconduct on the part of the police or investigating authorities. And when an arm of the state is responsible for prosecutorial misconduct and the individual's liberties at stake, there's ample justification for a different approach being taken. However, there's a second point to make here. And when one looks at Warren closely, one can see that the approaches are not so very different. And the defendants go too far when they say that affront to justice abuse in the criminal context operates independently of its impact on the fairness of any trial. The position is more nuanced than that. Can we look briefly at Warren, which you'll find at tab 22, which is volume 2 of the authorities, page 509. And the point that most clearly emerges from this paragraph, paragraph 36. Nevertheless, the board respectfully considers that the decision in Grant was wrong. The statement of paragraph 54 suggests that the deliberate invasion of a suspected person's right to legal professional privilege is to be assimilated to the abduction and entrapment cases, where the balancing exercise will generally lead to a stay of the proceedings. The board agrees that the deliberate invasion by the police of a suspect's right to legal professional privilege is a serious affront to the integrity of the justice system, which may often lead to the conclusion that the proceedings should be stayed. But the particular circumstances of each case must be considered and carefully weighed in the balance. It was obviously right to hold on the facts and grant that the gravity of the misconduct was a factor which militated in favour of a stay. But as against that, the accused was charged with a most serious crime, and crucially, the misconduct caused no prejudice to the accused. This was not even a case where the but-for factor had a part to play. The misconduct had no influence on the proceedings at all. In these circumstances, surely the trial judge was entitled to decide in the exercise of discretion to refuse a stay, and the Court of Appeal should not have held this decision was wrong. So that passage shows that even in an affront to justice case, impact on the proceedings is still a relevant consideration, and that the particular circumstances of the case must be borne in mind. The next point we want to make is a very short point about the disjunctive construction of the two limbs. One way we say the judge led himself into error was to rely on a disjunctive construction of the two limbs. We see that from paragraphs 41 and 43 of the bundle. That's core tab 8, page 127. Paragraph 41, it says, express power to strike out is contained in 3.42b. That provision has two limbs, the statement of cases and abuse of the court's process or is otherwise likely to obstruct the just disposal of the proceedings. Paragraph 43, he says the words given emphasis above show that the two limbs are disjunctive. The second limb can operate where there is no actual accrued or anticipatory future abuse of process. And that argument, we say, is wrong for the reasons we set out in our skeleton argument on page 50. That's tab 4, page 50. So the two limbs aren't disjunctive. Under the first limb, the concept of abuse of the court's process is not divorced either linguistically or as a matter of principle from the rationale for strikeout under the rule, namely that such abuse is likely to obstruct the just disposal of the proceedings. The rationale for striking out a claim for an abuse of process under the first limb is such that such an abuse is likely to obstruct the just disposal of the proceedings, and under the second limb, the court may also strike out a claim that is otherwise likely to obstruct the just disposal of the proceedings. The words otherwise likely highlight the relationship and continuity between the two limbs of 3.42b. Both are concerned with whether the just disposal of the proceedings is likely to be obstructed, and it's that which might justify the striking out. And so, to wrap up ground 2, I've sought to explain a number of fundamental problems with the judge's analysis. We say he's misapplied Arrow nominees and Van Hoekstraten. We say his analysis cannot be reconciled with other Court of Appeal authorities, including Tadorian and Sims, Hamilton and Al-Fayed and Rackett and Azima. And we say his analysis can be shown to contravene even the most basic principles that relate to abuse of process, which we cover in paragraph 19 of our skeleton. Finally, I need to note on this subject that the defendants asserted at paragraphs 37 to 38 of their skeleton argument. For your note, we don't need to look it up, it's tab 5, page 80. that we'd made a concession that was fatal to ground 2. Now, we don't accept that we made a concession, and we made our position clear in correspondence. The defendant's position is that they disagree with us, but they've indicated they would not object to a request for leave to withdraw the concession. And in the circumstances, we submit it's unnecessary for this court to resolve that question of whether or not there was a concession, since even if there was, it relates to a pure point of law and can, in an ordinary way, be withdrawn. So, my Lord, for all those reasons, I would invite the court to allow the appeal on ground 2. That leads me to ground 3, which only arises if we're wrong about ground 2. And the argument is that even the judge was right, there's a category of abuse of process concerned solely with the quality of behaviour, which doesn't involve assessing the impact of that behaviour on the future course of the case and the integrity of its determination. The judge was wrong to apply that category to the facts of this case. As we know, the judge relied on Hoogstraten. Van Hoogstraten was a very extreme case. The defendant was complicit in the murder. One can understand why in such an extreme case, and assuming for present purposes the judge was right about the law, the judge's category could be applied to Van Hoogstraten. And the question that arises is whether that category should be extended to the present stage, present case at this stage in the proceedings, before the judge is engaged with the critical questions of trial fairness and impact on the proceedings. And we say it's simply an error on the part of the judge to take that approach at this case. And on one view, we say the facts are not as extreme as those of Rakia and Azima, where there was hacking, as you know, and the claim wasn't struck out. And we say hacking is different and worse in one respect. It's clearly illegal, and because the hacking party gets access to whatever material is contained in the hacked account. Here, the only way in which BC could have acquired any confidential information was if the solicitor breached his most basic duties of confidence to his client. And importantly, although the Court of Appeal in Rakia assumed that the hacking was unlawful conduct for which Rakia was responsible, but they held no abuse of process, because the public interest in the court reaching the correct decision on the basis of all the evidence substantially outweighed such unlawfulness. We've seen that in paragraph 64 and 5. And of course, Van Hoogstraten was dealing with the most serious unlawful conduct that had made a fair trial impossible. And that last point provides an answer to the submissions made in paragraph 53(1) of my learned friend's skeleton, which you find on page 85. Well, 53(1), they talk about legal professional privilege being a fundamental human right. We don't dispute any of the propositions of law set out in that paragraph about privilege being a fundamental right, and so on. What we do dispute is the last proposition in the last two sentences of this paragraph, subparagraphs. It's at this bedrock at which any attempt deliberately to obtain privileged information strikes, therefore by its nature an abuse of process. And we've seen in Rakia that the Court of Appeal proceeded on the basis that the hacked documentation covered not just confidential, but potentially privileged material. But it was against that background the court held that even if Rakia had been responsible for obtaining those documents unlawfully, the public interest in the court reaching the correct decision would substantially outweigh any unlawfulness. They then deal with deterrence arguments in paragraphs 2 and 3, and they say the need to deter such conduct is also a reason why the law should recognise that privilege hunting is abusive, irrespective of any proven impact on the future course of proceedings. The racket extract we've been discussing, paragraphs 64 and 65, answers that submission. Even in a hacking case, considerations of overall justice and impact on the proceedings may negate findings of abuse. And they go on to say, in paragraph 3, that aside from this case, privilege hunting appears to be virtually unprecedented in the English courts. And they're wrong to suggest that. We've already been through Hamilton, which was such a case. We've already been through Rakia, which was such a case. And so too is the famous line of authority following Lord Ashburton, which deals with the issue by way of injunctive relief.
You accept, don't you, that it would be possible to restrain this conduct by injunction?
Yes.
And what are you restraining? What is the basis on which the court is acting in that hypothesis?
Restraining any attempt to obtain privileged material by privileged and confidential
Isn't
material.
it restraining an abuse?
Well,
The problem is we sometimes, I think, have the expression abuse of process to describe the whole thing,
yes.
such that you're reaching a conclusion that the continuation of the process should be stopped. Sometimes we're using it to describe conduct within a separate stage at which one addresses consequence or sanction. If you can get queer timid relief to restrain the conduct, I'd have thought that the basis of that application would be, well, the conduct is abusive.
Can I think about that? I'm tempted to say it's maybe just a matter of terminology. I'm not quite sure what the cause of action would be, but can I think about it and return to it? What they say about the importance of deterrence doesn't require there to be a finding of abuse of process of this stage before the questions of privilege and iniquity have been resolved. And so far as deterrence needs to be considered, it can be considered with all the other relevant considerations, including impact on the proceedings and overall justice.
Forgive me, the cause of action would be inducing breach of contract, wouldn't it?
Yes, thank you. It would. And inducing a breach of competence, stroke breach of contract.
And it wouldn't be an answer to that, would it, to say, well, actually, we hope that, in fact, we will discover iniquity?
No, you're absolutely not an answer to that. And they go on to say in paragraph 54 that the mere attempt to obtain an adversary's privileged documents is what necessitates a finding of abuse, even if privileged documents are not actually obtained. And they say the conduct is abusive because the English court process already contains a regime by which the adversary's documents can be obtained. Our answer to that is, in order to decide whether that process has actually been abused, and to win, one needs to know whether the disclosure regime has been undermined in practical terms. Abuse is not an abstract concept founded on subjective intention. It's a pragmatic jurisdiction founded on considerations of actual impact and overall justice. Our answer to paragraph 54 therefore flows from everything I've said so far. The approach advocated in 54 is not the approach to abuse of process taken in the authorities, which are concerned with overall justice, including the impact on the proceedings. Notably, on their case, a hacking case necessarily involves an attempt to obtain privileged material, and obtaining evidence legally is just as much an attempt to go outside the prescribed regime. Somewhat oddly, in paragraph 100, they say that collecting evidence unlawfully is not necessarily an abuse, but on their logic, it ought to be, because it's seeking to circumvent or sidestep the regime laid down for the production of evidence and for the disclosure of documents. So we don't actually see the distinction. Right? If the test is, if you seek to go outside the regime laid down for the proper conduct of litigation, you're automatically struck out, then you'd be struck out in a hacking case immediately. Have to be. And then they say in paragraph 55 that the few authorities on the point lead to the same conclusion. They're wrong about that for reasons I'll now explain. First of all, they rely on the Nigeria case, which will be familiar to this course. It was concerned with an arbitration award between Nigeria and P&ID. The tribunal awarded P&ID some 6.6 billion plus interest. And after the award, it emerged that through the course of the arbitration, P&ID was provided with many of Nigeria's internal legal documents. On that basis, Nigeria applied, among other things, under Section 68 of the Arbitration Act, to set aside the award for serious irregularity on the basis it was obtained by fraud, and that to enforce it would be contrary to public policy. Mr. Justice Robin Knowles held that the award to be set aside, and there are a number of reasons why this case ought to be distinguished from our facts. First, there was no question of the application of the iniquity exception. The material relied on to gain an unfair advantage was privileged. By contrast, if the material obtained by BC is not privileged, in line with my client's position, the material will be admissible and will on that basis be relied on to help prove fraud on a massive scale perpetrated by the defendants. For that reason alone, there's no proper basis for concluding at this stage that there was any analogy between the conduct in this case and the conduct in Nigeria. Secondly, the documents in that case were secretly retained and deployed to gain an improper litigation advantage, rather than their existence being volunteered by the claimants, which is our case. Third, the issue only came to light post-award. If the tribunal had known about this issue at an earlier stage, it could have or might have dealt with the matter differently. And fourth, as the defendant's submissions in paragraph 55(1) make clear, the conduct in question was held to amount to fraud by which the award was obtained. It is that which constitutes practicing the most severe abuses of the arbitral process. There's no question of the claimants obtaining a judgment by fraud in the present case, where the issues between the parties in relation to the status of the material has been brought into the open. The next case they rely on is Madarase, where they say they overstate what was actually decided. Can we look to see what they say in their skeleton, first of all, before I take you to the authority? They say in Madarase, Mr. Justice Bean implicitly accepted that it would be abusive for a litigant to meet with their opponent's former solicitors with the intention of extracting privileged information, albeit the requisite attention was not established on the facts. When one looks at Madarase, one sees that Mr. Justice Bean was making a series of factual findings rather than accepting implicitly or otherwise any proposition of law. The case is at tab 15 of the authorities bundle, starting at page 347. The background of that case concerned a dispute between Mr. Madarase and her former employer, the bank, Nomura. The bank terminated her employment. She then brought a claim alleging, amongst other things, unfair dismissal, sex discrimination, and victimisation. The tribunal dismissed her complaints and an application for review of the decision was dismissed. Eventually, she succeeded in obtaining an appeal hearing. Then Nomura attempted to have the appeal struck out. The basis for the attempt to strike out was Miss Madarase had met with Mrs. Howard, who was the person with conduct of Nomura's case before the employment tribunal, and she had recorded the conversation. At paragraph 27, we see reference to arrow nominees. I think we find that. And at paragraph 30, an attempt by the judge to summarise its effect. And that we find that on page 356. And the conclusion is that the law as laid down in arrow nominees is as follows. Little one, a claim by an employment tribunal and a first or second appeal from a decision on such a claim may be struck out as an abusive process if the claimant has been guilty of misconduct which jeopardises the fairness of the trial, so that a judgment in the claimant's favour would have to be regarded as unfair. That's clearly dealing with the first limb arrow nominees. Secondly, the risk to a fair trial is a very important factor, will very often be determinative, but it's not always conclusive. Where a party is attempted to pervert the course of justice by a flagrant campaign of deception, he forfeits his right to be heard. And little Roman 2, we say, is probably dealing with both limbs together, or at least acknowledging the overlap between the two in line with the submissions that I've been making. It's worth noting what the judge says after the semicolon. Where a party is attempted to pervert the course of justice by a flagrant campaign of deception, he forfeits his right to be heard. That additional part doesn't undermine or cut across the preceding acknowledgement that even in the context of the second limb, the risk to a fair trial is a very important factor. But even if one does treat his words as in isolation, the word attempt doesn't mean you ignore the impact of the conduct in question. In the context of a campaign of forgery, it's not the abstract attempt to forge that matters, but the fact that forgery has taken place, and that has a practical impact on the case. It is in that practical sense that there's been an attempt to pervert the course of justice. And in paragraph 33, the judge finds that a meeting did take place, and that what was said amounted to a clear breach of confidence on the part of Mrs. Howard. And that leads us to paragraphs 34 to 38, on which my own friend relies. In 34, he records a submission that both limbs of arrow nominees were engaged. And there's an important finding halfway down 35, starting at the bottom of page 357. I don't find she attended the lunch with the intention of extracting privileged information from Mrs. Howard. She was entitled to assume that an experienced solicitor would distinguish between what could properly be said and could not. I accept the truth of what she said in evidence that lunch came about because during her telephone conversation with Mrs. Howard.
Well, Mr. Justice Bean makes what some people might think are quite generous findings about Ms. Madarassi. But there's nothing comparable in our case, is there, where the precise purpose of Black Cube was to seek to extract whatever information they could from X by a campaign of deception.
Well, they may have also been trying to find out to what extent X might have been involved. I don't know, but certainly the outcome was the obtaining of information, which subject to whether or not subject to the iniquity principle and or whether it's already in the public domain. Would be
well, the judge finds, and he's seen the material and we haven't, that
yes.
The Black Cube operative kept steering the conversation back
Yes,
to...
I withdraw my last observation. You're quite right.
Okay. Yeah.
I'm just lost. Forgive me for a moment. Where do I find this? What judgment I've just lost? I don't find. I've already read it. I'm sorry, I misread my notes. So the judge goes on at 37 that say she took the tape recorder, etc., and he says in the last sentence of 37, in the event the tape recording is proved useless except as set out above, namely as evidence supporting the agreed fact of the meeting having taken place, accordingly I don't find that in attending the lunch meeting and listening to what Mr. Howard had to say, Miss Madarassi was attempting to prevent a fair trial. And this is the passage that the other side rely on as saying that he was implicitly accepting that it would be abusive with us to meet former solicitors of the other side with a certain intention. But all he's doing is making findings of fact. He's not expressing any finding of law. And it's just a stretch to say he's implicitly accepting there's an abuse. He's just saying what happened and why he concludes that she didn't have the requisite intention. Doesn't provide a launching off pad to say that an attempt to obtain privileged information is per se an abuse. And insofar as 55.2 is an attempt by the defendants to present the judge's implicit understanding of the second limb of our nominees, the better indication as to how he understood it is in the paragraph in which he summarises it. I've already taken to paragraph 30. And if we drop down to 41, we see how the judge expressed his overall conclusion on the second limb of our nominees. Her conduct is not remotely comparable to the forgery and campaign of deception. In my judgment, Numero has fallen short of establishing that the second limb of our nominees, even as expressed by Lord Justice Ward, applies in the present case. And he went on to find there was no question of fairness of the trial being jeopardised, and that's quite different to the way in which the defendants characterise Mr. Justice Bean's approach to the second limb of our nominees in their skeleton argument. They then, in paragraph 55.3, back to page 87, rely on the criminal cases. However, their submissions tend to support rather than detract from our position. In particular, they acknowledge that the approach in grant is wrong, that a stay should always be granted regardless of prejudice, and we don't understand how they square that with their case that prejudice is irrelevant under the second limb of our nominees, and I've already explained to you why the Warren approach is consistent with how we present the law. And as we've said, sorry, I haven't said this already, we've quoted selectively from the relevant extract in paragraph 36, which I showed you earlier. And perhaps we can just bring that up again briefly in the Authorities Bundle, tab 22, page 509. The part they've admitted is from the sentence, but the particular circumstances, let's see, particular circumstances of each case must be considered and carefully weighed in the balance. And so, for my lords, for all those reasons, we invite your lordships to allow ground 3 in the event that it arises if we're wrong about ground 2. Now, ground 5 doesn't require much, if any, elaboration. It's just following through the consequences of grounds 2 and 3. We deal with the point in paragraph 28 of our skeleton, all bundle tab 4, page 53. We say if either of grounds 2 or 3 is well founded, ground 5 is the judge's decision to strike out the summary judgment application, alternatively to refuse summary judgment as a matter of discretion, was wrong. The decision would be premised on an error of principle, namely the errors identified in grounds 2 and 3. Moreover, the judge failed to take into account relevant matters. Most significantly, he failed to take into account the possibility that the conduct in question might have no real impact on the proceedings. This is because it's possible that the information review hearing, the judge will conclude that the material obtained from X by the BC operative is not confidential or privileged, including because of the operation of the iniquity exception. This is a very real possibility. The judge himself indicated on an initial analysis that there are arguments either way on privilege and iniquity. The judge also took into account irrelevant matters, namely erroneous conclusion on abuse of process. That leads me to ground 6. Can we bring up core bundle, tab 1, page 16? Ground to appeal is tab 1.2. And ground 6, the judge erred in striking out the summary judgment application, alternatively declining as a matter of discretion to enter summary judgment or to make an additional order before the status of the so-called illicit knowledge, including the application of the iniquity exception, and whether such knowledge is already in the public domain, had been resolved. Without prejudice to the generality of the foregoing, the premise of the judge's reasoning on abuse is that the claimants were seeking to obtain privileged or confidential information from the defendant's solicitor. However, if the iniquity exception applies, the communications in question are therefore neither privileged nor confidential. The judge's reasoning is therefore internally inconsistent. The judge relied on a premise that the material is or may be privileged or confidential, while declining to decide whether the iniquity exception deprives the material in question of confidentiality and therefore privilege. And relatedly, in deciding to strike out the summary judgment application, the judge weighed the protection of the court process and the sanctity of legal professional privilege as factors in favour of strikeout, without deciding whether any privilege exists. According, the balancing exercise was flawed. Further, while giving undue weight to the factors identified in subparagraph 2 above, and the absence of a decision on the privileged confidentiality issues, the judge, in conducting his balancing exercise, gave insufficient weight to the strength of the fraud case against the defendants and the strong public interest in exposing and remedying serious wrongdoing such as fraud. And we cite Rack here, we say which ought not to be confined to post-trial situation. And an obvious analogy can be drawn between Rack here post-trial and a case where summary judgment ought to be granted. There are a number of different strands to this ground, but one way of thinking about it is an extension of ground 2. Ground 2, in a nutshell, is that one cannot decide the first stage in the analysis, namely whether certain conduct constitutes an abuse, without considering the consequences of that conduct. The key aspect of ground 6 is that one cannot decide the second stage in the analysis, namely the sanction for any abuse of process, without considering the consequences of that conduct. Even if you're not with me on ground 2, the answer to the ground 6 is in our submission clear. And the proposition that one ignores the consequences of the conduct in question in the context of deciding on sanction is contrary to principle. Deciding on sanction is quintessentially an issue that requires all relevant circumstances to be weighed in the balance to impose an appropriate sanction a sanction that's appropriate, proportionate and just. The idea that consequences are to be excluded from consideration when considering sanctions is simply wrong. And those submissions follow as a matter of principle. And we say the authorities clearly support that view. And it is convenient to start with the Supreme Court authority of Summers and Fairclough, which appears at tab 24 of the bundle. So that's volume 2 for those using hard copies. And you will recall, I hope, that I've already taken you to various paragraphs from Summers and Fairclough when I was going through Rackham.
Yes.
And I don't need to go through those paragraphs again. I do want to also show you paragraphs 42 and 48. Paragraph 42 can be found on page 572. Under the CPR, the court has a wide discretion as to how its power should be exercised, see Baguzzi. So the position is that the court has the power to strike out a statement of case for abuse of process, but at the same time has a wide discretion as to which of its many powers to exercise. The position is the same under the inherent jurisdiction of the court, so that in the future it is sufficient for application to be made under the CPR. We see no reason why the conclusion reached should be any different whether the application is made under the CPR or the inherent jurisdiction of the court. And then at paragraph 48, which I think starts on the next page, 573, it's in the public interest that there should be a power to strike out a statement of case for abuse of process, both under the inherent jurisdiction of the court and under the CPR, that the court accepts the submission that in deciding whether or not to exercise the power, the court must examine the circumstances of the case scrupulously in order to ensure that to strike out the claim is a proportionate means of achieving the aim of controlling the process of the court and deciding the case's justly. And we submit that the three very clear points that emerged from this authority. First, the court has a discretion as to how to exercise its powers, including the power to strike out a claim. Secondly, the power is to be exercised in accordance with the overriding objective, which is to determine cases justly. Thirdly, and critically for my appeal under ground 6, the court must examine the circumstances of the case scrupulously and must ensure that to strike out the claim is a proportionate means of achieving the aim of a just result. And we fail to see how those fundamental principles could be reconciled with the proposition that one doesn't need to take into account the impact of the abuse in question when deciding on the appropriate sanction. Examining the circumstances of the case scrupulously, taking all circumstances into account, and deciding on a proportionate response, all necessitate taking the impact or consequences of the abuse into account. And it should be noted that these fundamental principles have been applied in other cases, including cases where the application to strike out is made early in the proceedings. One such example is the Municipio and BHP case, which you find in tab 38. That's the beginning of volume 3 of the authorities bundle, starting at page 960. So that is the middle of the case. The actually starts at page 907. I want to pick up just 2 paragraphs at page 960. Paragraph 177, the finding of abuse doesn't lead automatically to a striking out of the claim. The court then retains a discretion as to the appropriate response, which must always be proportionate. Finally, but importantly for present purposes, litigants should not be deprived of their claims without scrupulous examination of all the circumstances and unless the abuse has been sufficiently clearly established. The court cannot be affronted if the case hasn't been satisfactorily proved. Thus, it's been stated repeatedly that it's only in clear and obvious cases that it will be appropriate to strike out the proceedings in the abusive process so as to prevent a claimant from bringing an apparently proper cause of action to trial.
This is not a case, is it, where the abuse has not been sufficiently clearly established? I mean, we know what Blackhew did and we know what they got.
Well, without wanting to rerun ground 2, I hear what you say.
No, I appreciate there needs to be, you say, consideration of impact on the proceedings.
Yes.
All of that. So I wasn't.
Sorry, I misunderstood you.
If it's simply a question of, it says here, unless the abuse has been sufficiently clearly established.
Well, the approach to BC has been sufficiently and clearly established. I accept that.
Yes.
Have to.
Yeah, of course.
And similar points emerge from the Court of Appeal case, Cable and Liverpool Victoria Insurance, that I've already taken you to. You will recall that there the court emphasised that the question to strike out was a 2-stage test. Striking out was a remedy of last resort, and when deciding the second stage, it was necessary to consider whether the remedy was proportionate to the abuse. Now let's look at what the defendants say about ground 6. We find that in their skeleton argument, core bundle 5, page 87. And they say, they deal with grounds 6 in paragraphs 57 to 9. They say in 58, grounds 6 and 7 arise on the hypothesis that grounds 2 and 3 fail. Thus, these cases that despite C's ex-hypothesized abusive attempt to obtain D's privileged material, no sanction should be imposed until further time, money is spent investigating the extent to which the attempt succeeds. The point needs only need to be so stated to expose a lack of merit on it. And then they say, secondly, suffer from a simple failure to distinguish between attempts and outcomes. For example, C's contend because the judge didn't determine whether the iniquity exception applied and therefore whether Blackhew evidence is in fact privileged, the judge could not properly determine that the claimants were seeking to obtain privileged or confidential information. This is a known sequitur. There's no reason why one cannot attempt to obtain privileged information, even if the information once obtained turns out not to be privileged, or indeed even if the attempt fails altogether and no information is obtained. Now, we have no problem with the way they formulate the relevant question. When can a sanction be imposed? The answer is when the circumstances of the case have been properly assessed, so that a proportionate response may be made. The circumstances of the case must include impact. And we disagree with their proposition in paragraph 58 that the proposition their submission that the proposition need only be stated to expose a lack of merit in it. Yet again, they're assuming what they set out to prove. And one could test it this way. First, let's imagine a hypothetical situation where a defendant is spotted surreptitiously rummaging in the notebook of leading counsel. As it happens, the notebook is blank, so the very serious misconduct is incapable of having any impact on the proceedings in question or the case as a whole. The defendants say you can and should ignore the fact that the notebook was empty when deciding on sanction, but that makes no sense and is inconsistent with the authorities that I've taken you to. What if the notebook was not blank but full of the most sensitive privileged information, which would have a profound impact on the future of the case? Surely the appropriate sanction would need to take account of these important considerations. Yet on the defendant's case, those considerations don't matter, because you can, they say, and should decide on sanction without assessing whether or not the conduct in question was significant or insignificant, impactful or not. And that position, we say, is untenable and not supported by any authority. Secondly, let's imagine a situation akin to the Nigeria case, where privileged documents are obtained by nefarious means and then kept and relied on in secret in order to obtain an advantage during the trial. The point only emerges towards the end of the trial or after judgment has been entered. Let's further imagine that the privileged information had a decisive impact on the outcome of the trial. How could one sensibly and proportionately impose a sanction without taking into account the particular circumstances of the case, including whether the attempt to obtain privileged information was successful, and if so, what the impact had on the proceedings? And we submit that the defendant's position, which is that it's not necessary to take those matters into account when imposing a sanction, only needs to be stated to expose the lack of merit in it. So for all those reasons, we invite your lordships to allow ground 6 of our appeal. I'm looking at the time. I've got 2 very short grounds, which will be probably about 10 minutes after the short adjournment, if you'd like to rise now.
Yes, all right, if that's convenient, we'll resume at 2 o'clock.